Patrick said, today we're going to go over some information related to preparing for a Department of Labor health plan audit. And on the call with me today, I also have my colleague Erin Marjorie, who is an employee benefits attorney as well and has lots of experience dealing with health plan and ERISA compliance, as well as dealing with DOL audits for a number of clients in the past. So in addition to that information, we just have a little bit of an introduction to share. In fact, Erin and I both have worked in the employee benefits area in private practice, representing clients with respect to their ERISA and other compliance issues. Now we focus more on educating employers about their compliance obligations and working with groups like Synergy Solutions Group to help provide educational materials, webinars like this, and other types of compliance resources so that we can help a broader group of employers. And sitting in on a webinar like this is a really great step for you to become familiar with some of these issues that face employers when they are providing these benefits to their employees. So of course, doing that is really great for things like recruiting, retention. People tend to come to expect that they're going to be able to just have their job and the benefits are going to go along with that. So it's really great for employers that are able to provide those benefits. But of course, it's not necessarily easy to make sure that you're following all of the rules that might apply. So becoming more knowledgeable about those is definitely very helpful. Before we dive into some of the substance of our presentation, I also have some information about logistics. As I mentioned earlier during the audio checks, you can call in to listen to the audio, or you can listen through your computer speakers. If you would like to switch over to the phone at any time, if you're listening through your computer, you can do that. And you would just need to call in using the phone number listed here and then enter the access code when you are prompted. Erin has also put that information over in the chat so that you can refer to it at any time. And the chat window may or may not be open for you right now. If you're not seeing those messages from Erin, just go ahead and go up to the top right-hand side of your screen and look for the button with the speech bubble that says chat. If you click that, it will open that up for you. All attendees are going to be in listen-only mode today, so your lines are muted. That being said, though, you will have the opportunity to ask questions. You'll just do that by using the Q&A feature that we have, which is very similar to the chat that I just mentioned. So in order to access that Q&A feature, if it's not open for you already, just go up to the top right-hand side of your screen again and look for the button that we have outlined in red here, the question mark that says Q&A. If you select that button, it should open up the Q&A panel for you, and you can type your question in and click send. We do suggest that you select send to all panelists before you submit your question, and that's just to make sure that Erin and Patrick and I can all see them so that we can answer as many questions as possible. Keep in mind that we will save any questions until the end of the session, and that's just to make sure that we can get through our planned material first, and we'll turn our attention to any questions that have come in. And if for some reason your question is not answered today, or if you have questions that come up after today's session, please feel free to reach out to your contact over at Synergy Solutions Group. And as Patrick mentioned, there will be some follow-up after today's webinar as well. So there will be a really easy way for you to get in touch. So here we have the agenda for today. So we're going to start out talking about an overview of Department of Labor audits of health plans. And we'll start out as well by talking about some triggers of audits and what the process looks like. We'll talk about how to do a plan compliance review and some things to look for, as well as certain specific requirements that may come up in the DOL audit. So when the DOL comes and audits a plan, what types of things are they looking for, and what types of things do you want to make sure that you have reviewed ahead of time? So we'll talk about the requirement to have a plan document. We'll talk about reporting and disclosure rules. also fiduciary responsibilities, and then we'll take a look at some health plan requirements and healthcare reform requirements under the Affordable Care Act that are starting to become part of these DOL audits. And we'll take a minute to talk about some record-keeping requirements and recommendations as well. So we'll finish up with that, and then we will, as I said, have some time for questions. So to start out, let's talk about an overview of DOL audits. First, we'll take a look at ERISA. So this is the federal law really that governs employee benefit plans. It stands for the Employee Retirement Income Security Act. And you can tell, it says retirement in the title, but really we're not talking about retirement plans here. We're talking about other types of health plans and maybe other types of welfare plans. Well, ERISA was passed back in the 1970s to provide certain protections for individuals who had retirement plans or programs or pension plans promised by their employers. A few things, some really high-profile cases happened back then with employers promising retirement benefits to their workers and then going back on those promises so that people were left in their retirement years without any method of funding their retirement. So they had relied on the employer's promises, and then those promises were taken back. So the federal government stepped in and said, you know what, we need to have some standards for when employers are promising these benefits to their employees. And that started out with a big focus on pension and retirement benefits. Since 1974, ERISA has expanded quite a bit, and it does include provisions specific to health and welfare plans as well. We can see on the bottom of the slide there are a number of sections of Title I of ERISA, which is the protection of employee benefit rights. And we just have the sections listed here that impact group health plans and welfare plans. The sections that are not listed relate to pension and retirement plans. So you can see some of these items match up with the things that we mentioned for our agenda for today, so we will cover some of them in more detail. So the Department of Labor is responsible for enforcement of ERISA, and they do have a very broad authority to audit employers and plan sponsors for their compliance with ERISA. The portion of the Department of Labor that is responsible specifically for conducting these audits is called EBSA, or the Employee Benefit Security Administration. So when employers hear from the Department of Labor with respect to being audited, they're generally going to be hearing from EBSA specifically. To perform the audits, EBSA employs over 400 investigators, and they work out of different field offices. And investigators and auditors are all different. They all have their various ways of conducting audits or what they look for specifically, but they do have certain things in common. They usually have advanced degrees. Some are lawyers or CPAs, and they generally have lots of experience and knowledge in business and finance. So we are talking about a rather sophisticated level of review. When there is a DOL audit, it will normally focus on violations of ERISA's fiduciary obligations, as well as their reporting and disclosure requirements. The DOL might also investigate whether an employee benefit plan complies with ERISA's protections for plan participants, things like special enrollment rules for a group health plan or mental health parity requirements. And recently, the Department of Labor has started using this investigative authority to enforce compliance with the provisions of the Affordable Care Act or the healthcare reform law. So normally, kind of as we talked about and traditionally, Department of Labor audits have focused primarily on retirement plans like 401k plans or pension plans. But now that the Department of Labor has started enforcing compliance with the ACA, and that included so many changes for health plans, health plan audits have started to increase. And being selected for an audit can have some pretty serious consequences for an employer. The DOL provides enforcement information, and according to their audit report for the 2013 fiscal year, almost 3 out of the 4 investigations that they did resulted in some sort of penalties or required other corrective action, like paying amounts to restore losses, getting rid of profits, or making sure that claims were properly processed and paid. So some sort of activity that the employer had to engage in, or some sort of cost they had to pay in order to address these violations. Now, of course, in addition, a Department of Labor can just be stressful and time-consuming. It can negatively impact your normal business operations because of the time that is needed to just review the items that the Department of Labor wants to look at and to respond to their requests and deal with any follow-up questions that they have as they are reviewing your compliance. So that's just one more thing added onto the pile of things that employers are already responsible for. So dealing with something like that that's out of the ordinary can be a burden. So because a DOL audit can be so disruptive to your day-to-day business operations and maybe result in penalties or some other sort of corrective action, we definitely think it's important for employers to know how they can prepare for a DOL audit and possibly how you might be able to avoid an audit of your health plan. Now, the best time to think about this, the best time to prepare for this is before you are the subject of a DOL audit. So preparing for a potential audit that could theoretically happen can help you analyze whether there are any problem areas that the Department of Labor might identify so you can fix them ahead of time, rather than scrambling if the Department of Labor then comes to you and asks for something you don't have, or you take a look at it and realize you've been doing something wrong. So just doing some work on the front end in case this is an issue for you can really save you a lot of time and a lot of headaches. So one important thing to know is how to understand why the Department of Labor selects certain health plans for audit, so you can potentially take some steps to minimize that audit risk for your own plan. So understanding how the audit process works can also help you deal with an audit effectively and efficiently if one does happen. So as a general rule, the best way to prepare for a DOL audit of your health plan is just to make sure that your plan is in compliance with any applicable federal laws that the Department of Labor might be reviewing, things like HIPAA or the Affordable Care Act, and we'll talk about some more of those things later on. It's also important, of course, to have documents that prove your compliance and to maintain the documents so that they're easy to access in the event there is a DOL audit. So if you take some of these steps before your plan is selected for an audit, it can definitely reduce your exposure to penalties, and it can also make the audit process more manageable and less time-consuming and problematic for you. So next we'll take a look at some common audit triggers and the process for a DOL audit. A DOL audit can be triggered for a variety of reasons. In most cases, the DOL investigator is not going to tell you why your health plan was selected for an audit, but there are some common triggers that you should keep in mind. So participant complaints are a common trigger. So a participant in your plan or an employee can complain to the Department of Labor about what they think is an ERISA violation. So in 2013, according to that DOL audit summary, there were 775 new investigations that were opened as a result of participant complaints. And actually, this reminds me of a situation that came up when I was a relatively young benefits attorney. Many of my friends, had just gotten their first jobs and were involved in employee benefit plans. one of my friends came to me and said, oh, I hear you're an employee benefits attorney. I think my employer is doing something weird with my 401k contributions. They're taking them out of my check, but they're not going into the 401k account. They're just keeping them until they feel like putting them in. And I was able to point to some DOL resources, and there are very strict rules on that type of thing. So the employer was not following their compliance obligations. They were not putting those contributions where they belonged. Now, fortunately, my friend was able to show his employer or go to HR and say, hey, I think this is not going quite right. Can we do something about this? They realized their mistake and took steps to fix it. But if you have a disgruntled employee or someone who is not happy about what's going on with their plan, or maybe the employer is not as cooperative, that person could easily have gone to the Department of Labor and said, my employer is stealing my money and not putting it in my 401k plan. I think you should investigate them. Also, answers on the plan's Form 5500 can potentially trigger an audit. So, for example, if the plan, if their Form 5500 is not complete, or if there are some strange answers where maybe they're inconsistent from year to year, the Department of Labor might identify that as a red flag and decide that they need to investigate that plan further. Also, the Department of Labor might have some national enforcement priorities or projects, and those are used to target the Department of Labor's resources on certain issues. So, for example, we have the DOL's Health Benefit Security Project, and that focuses on making sure health plans and health insurance issuers are in compliance with the mandates of the Affordable Care Act. Now, what are some steps that you can take to potentially avoid an audit or at least minimize your exposure? As a practical matter, you might have little control over whether the Department of Labor decides to audit your plan. We talked about some of those triggers, but in some cases it can be truly random. So you may not have a ton of control over that, but you can definitely take some steps to help minimize your exposure. So first of all, you can respond to any participant questions or requests for information in a timely manner. So just like my friend who had this issue with his plan, if the employer is cooperative, maybe doesn't just ignore a request or stonewall or say, no, we don't have to worry about what you're concerned about, responding to those requests can be helpful to help you avoid some of those triggers. If you are subject to the Form 5500 requirement, making sure to file that form on time, making sure it's accurate and complete can help avoid that common trigger. Making sure that you distribute your participant notices that are required by law. So, for example, a summary plan description or the new requirement for a summary of benefits and coverage. If you make sure you distribute those by the deadline, that can help avoid that common trigger. And making sure that you're keeping your governing plan documents up to date. So making any updates to your plan document or your summary plan description on time to make sure they accurately reflect any legal or plan design changes. That can help as well with just making sure we're avoiding confusion or complaints by your participants. So each year, thousands of employee benefit plan fiduciaries and plan sponsors are selected by the Department of Labor to be audited. So this slide talks about the audit process, and knowing how that DOL audit process works can definitely help an employer more successfully respond to an audit and navigate an audit as it's going on. So step one, normally, when the Department of Labor selects a health plan for audit, they will send out an audit letter or an investigatory letter. So this letter will notify the employer that a Department of Labor investigation will take place. We can have a couple of different types of investigations. We might have a limited review investigation or a full-scale investigation. So we might be looking at just one narrow part of the plan or the compliance issues, or maybe they're kind of trying to look for everything that might be an issue. Regardless of how broad it is, the next steps for going through the audit are very important to help reduce an employer's liability and making the investigation run as smoothly as possible. So step 2 is responding to the document request. Normally, that initial letter from the Department of Labor will include a request for a list of documents related to the plan. Employers that receive those audit letters might be surprised by how extensive those requests are, might be overwhelmed by the number of documents that the department wants to look at. And like I said, even though you might generally have no way of knowing whether you'll be selected for an audit, it is important for employers to make sure that they are maintaining those employee benefit plan documents in an organized fashion. So if an audit does occur, it is easier for you to respond to the DOL document request. It's also important to comply with any applicable deadlines, so that's what we have outlined as step 3. Normally, the audit letter will request that you provide documents by a specific date. So it's very important to respond by this deadline. If you have an inadequate response or a late response, that could raise some red flags for the DOL, and it could trigger additional document requests. Maybe they would want to do interviews or an on-site visit, or that could lead just directly to some DOL enforcement action. So on this next slide, we have a list of documents that the Department of Labor might request as part of that investigatory letter. Now, I'm not going to read every single item on this slide, and it's pretty tiny, but it is just intended to give you an idea of how many things the Department of Labor might look for. So we've seen a number of varieties of very specific audit letters from the DOL, so examples that they have actually sent to employers, and they will have a number of things in common. But just keep in mind, when you are sponsoring a health plan, ideally you would confirm that you have these documents and records when you're responding to an audit. You should just be able to pull them from records you have related to the health plan, including things like your plan document and your summary plan description. These are not things the DOL is looking for you to prepare or create in response to their letter, because they're looking back at what have you been doing up to this point. And because there's generally a paper trail for all of these things, if you've had them in place, the Department of Labor is not necessarily going to be fooled by you putting these things together at the last minute, because they send you a letter asking for it and you say, oh no, we haven't done that, we better make one really quickly. So the ideal situation is to have these documents and be able to just pull them together and gather them once the DOL wants to see them. So once an employer knows that it is being audited by the Department of Labor, there are a number of things it can do to help prepare for the investigation. So here are some steps to consider. First off, establish a contact person at your company to help deal with the investigation. So this is someone that can be the main point of contact for the DOL investigator. If you would like, you may want to consider hiring legal counsel for assistance with the audit process, or if you have an attorney that you work with related to your benefits issues or compliance, this would be a good thing to let that person know. It is possible that you could negotiate or clarify the scope of the document request that the Department of Labor has provided to you. It's possible, if necessary, that you could ask for an extension to the response deadline. So the Department of Labor will work with plan sponsors. They will work with employers, especially if you have a good reason for that, if you're trying to pull the information together and making some good faith efforts, they may be able to work with you on the timing. Making copies of the documents that are requested and reviewing them for accuracy in order to possibly explain any discrepancies can be helpful. And also prepare your staff for the potential for on-site visits and interviews. So in some cases, depending on what comes out of that document review, the Department of Labor investigator might want to look a little further into certain aspects of your plan administration. All right, next we'll talk about a compliance review. So we're going to talk about some of the compliance issues that you might want to look at in advance of potentially being selected for a DOL audit. Before I dive into that, I just want to remind everyone that if you have any questions, you can enter those using the Q&A feature. You just need to look for that button with the question mark that says Q&A. And if anyone has questions, we'll come back to them at the end. So on this slide, we have some information about health plans that are subject to ERISA. So we talked about kind of the DOL audit process, but what plans that you have, specifically health plans, might be subject to ERISA? And actually the answer is lots of them. Most health plans that private employers maintain for their employees are going to be subject to ERISA. There are only very limited exceptions to ERISA at all. And because of this broad reach, the structure of your organization or your company is not necessarily going to matter. Plans that are sponsored by corporations, partnerships, sole proprietorships, or nonprofit organizations are all subject to ERISA. The limited exemptions relate to government plans and church plans. And determining whether you have a government or a church plan, especially if we're talking about church-affiliated organizations that maybe are not themselves churches, can be somewhat complex. So that's kind of outside of what we're going to be talking about today. But just keep in mind, if that does come up for you, that it is something that can be a little bit more detailed than just saying, oh, it's a church plan, we don't have to worry about it. So being surprised by being subject to ERISA is not necessarily a position you want to be in. So that's definitely something to keep in mind. So ERISA includes a number of requirements. We kind of saw that on the first slide when we were looking at the Title I sections, but there are specific requirements that we'll go over today related to having a plan document, having to do certain reporting and disclosure. There are specific responsibilities for fiduciaries of a plan. The Affordable Care Act has added new requirements. And there are specific requirements for health plans under COBRA and other types of group health plan requirements. And we'll talk about some of those coming up. Next, I'm going to turn things over to Erin, and she is going to look more specifically at some of these compliance issues, and she'll start off with the plan document.
Great, thanks, Erica. As Erica was mentioning, the best way to prepare for a DOL audit of your health plan is to confirm that your plan is in compliance with applicable law. Because DOL audits of health plans are becoming more and more frequent, it's more important than ever for employers to review their health plans for compliance now before they're selected for an audit. So over the next few slides, I am going to be talking about some of the main compliance requirements for health plans. And the first one I'm going to start off with is the plan document requirement. When the DOL comes knocking, one of the very first things that they're going to ask for is a copy of the plan document. Under ERISA, every health plan has to be established and maintained pursuant to a written plan document. ERISA does have specific content requirements for plan documents that I'll talk about more in a minute. But basically, the purpose of a plan document is to help participants understand what types of benefits are available under the plan, but even more so, it serves as a guide to the employer to help administer its plan. So through the plan document, the employer makes its design decisions about the health plan, and it also should use the plan document to administer the plan. Although ERISA requires a plan document, it doesn't say specifically what that document has to look like. Often when there's an insured plan, a wrap document is used. In an insured arrangement, the benefits are going to be described in that insurance contract or certificate. However, this insurance document doesn't include all of the ERISA information. The insurance document is prepared by the health insurer to comply with applicable state law requirements, so state insurance requirements. The insurer isn't thinking about ERISA when it drafts that document. So a common and practical approach for employers to use is to have a wrap document that would be combined with that insurance contract or policy, and it would include that information that's required under ERISA that is missing from the insurance document. Sometimes employers will decide to include multiple benefits under one plan document, and this can help simplify plan administration. So they may decide to group their medical, their dental, their vision, their life, all under one plan document. That can make it easier to maintain a plan document, help with amendments, that sort of thing. And also, if an employer is subject to the Form 5500, the employer would then be able to group its benefits under one Form 5500. Although ERISA doesn't tell us what the plan document has to look like, there are certain content requirements for the plan document. In addition, there are some topics that ERISA does not require a plan to cover, but that should be included in the plan document to help in case a legal dispute over benefits arises, or just to help make the administration of the plan run more smoothly. The plan document should include information about the plan's benefits and eligibility to participate in the plan, how the plan is funded, so if the plan is fully insured, self-insured, or has a combination of those benefits. For insured plans, it should talk about how any insurance refunds or rebates will be used. It should talk about how benefit decisions will be made, including the standard of review for any court decisions involving benefit claims. Also, the plan document must specify one or more fiduciaries who have the authority to help or the authority to control and manage the plan. It must describe the procedures for making amendments to the plan or terminating the plan. Also, for group health plans, information should be included on laws that pertain to group health benefits. So, for example, the rules for COBRA continuation coverage or HIPAA portability rules, like the special enrollment right rules. Plans covering medical expenses should also include provisions regarding subrogation, reimbursement, and coordination of benefits. And then the plan document should also address any procedures for how responsibilities are allocated for operating the plan and administering the plan. In addition to requiring a plan document, ERISA also requires health plans to comply with certain reporting and disclosure requirements. The first document that we're going to talk about is the Summary Plan Description, or the SPD. This is probably the most important document for a plan to have because it communicates the benefits provided by the plan to participants, along with any rights or obligations that participants have under the plan. During an audit, the DOL will pretty much always ask for a copy of the plan's SPD. And again, the SPD is a really important document because it tells participants what they can expect under the plan. These documents should be very carefully prepared and reviewed. This is because when there is a discrepancy between the plan document and the SPD, say the SPD's terms are more favorable to participants than the terms of the plan document, or the employer's intent regarding the plan. The courts have often ruled that the SPD's terms will be enforced if those terms are more beneficial to plan participants. So bottom line, employers need to be careful in terms of what they tell their employees regarding the terms of the plan. ERISA requires virtually every health plan to have an SPD and to provide the SPD to plan participants. Exceptions are very limited. There's an exception for employer-provided daycare centers, and there's also an exception for plans that are provided to a select group of management or highly compensated employees. That's it. Otherwise, plans must have an SPD, no matter how small they are. There is no small employer exception to the SPD requirement. This is an area where there is some confusion. There is a small employer exception to the Form 5500 requirement, and I think sometimes the two concepts are confused, and employers might think that because they're not subject to the Form 5500, they're also not subject to the SPD requirement. That's actually a question we get fairly regularly. I actually just answered that question yesterday for a client. So again, important to remember, although there is an exception for the Form 5500 filing for small employers, there is no exception for the SPD requirement. In terms of who is responsible for the SPD, that would be the plan administrator. And typically, the plan administrator is going to be the employer who sponsors the plan. Even if an employer uses a third party to help draft the SPD, which is commonly done, that employer still retains the legal responsibility for making sure that the SPD is a correct summary of the benefits and also for providing that SPD to participants.
Actually, Erin, before you move on to the next slide, I just had one thought to share as well. You know, we do get a lot of questions from those small employers. You know, I thought I was exempt from having to provide the SPD because I'm small. In addition to that, we get a number of people just saying, well, I thought I was exempt from ERISA altogether because I'm a small employer. Not just the SPD requirement, but everything we're talking about today. I don't have to worry about ERISA, right? And that is, unfortunately, for those small employers, not correct. So everything we're talking about today, unless we are mentioning an exemption, applies regardless of how big or small the employer is. It's just the fact of offering this employee benefit plan that the DOL, wants to make sure that you're following the rules that apply.
Thanks, Erica. That's a really good point. Next, we're going to talk about the deadline for distributing SPDs and also the acceptable methods for getting the SPD into the hands of your employees. So first of all, an SPD must be provided to a plan participant within 90 days of when that participant first becomes covered under the plan. This is a pretty generous deadline. Employers will typically try to provide the SPD more quickly than that, just so people have an idea of what type of benefits that they're eligible for and enrolling in. Often SPD will be provided with any enrollment materials. Also, an updated SPD booklet must be provided every 5 years if there have been any material changes to the information within that 5-year period. Sometimes we get questions from employers wondering if they need to reissue the SPD every year. There is no requirement to do that, although if you are making changes to your plan, then you would want to somehow communicate those changes to participants. I'll talk more in a minute about how that can be done outside of preparing a whole new SPD booklet. Usually the SPD is going to be, it all depends on what type of benefits are covered, but it's not unusual for an SPD to be 30 or 60 pages long. So you definitely don't want to be recreating that and redistributing it every year unless you feel like you need to. If there have been no changes to the SPD, then the deadline for redistributing it is every 10 years. As a practical matter, that doesn't really come into play all that often because, as we know, health plans do generally tend to change from year to year. In terms of delivery, ERISA requires that the SPD be delivered in a way that ensures that participants actually receive it. Some of the most common methods used for distributing the SPD are first-class mail or hand delivery in the workplace. So again, you want to make sure that participants are actually receiving it. Putting the SPD out in a break room on the table is not okay unless you're also mailing it or hand delivering it. Electronic delivery or posting it on an intranet is sometimes acceptable, but the DOL has very specific requirements that have to be met before employers can use that form of delivery as an acceptable method. So we talked about the content requirements for plan documents a few moments ago. There are also detailed content requirements for an SPD. So first of all, the SPD has to include information that identifies the plan, so participants know what plan they're covered by. And that would include things like the plan name, the name and address of the employer who sponsors the plan, the type of plan, so is it a health plan, is it a dental plan, is it a vision plan, also how the plan is administered. So is it administered by an insurer, by a TPA, that sort of information. It also has to include a detailed description of what benefits are covered by the plan and also what the plan's rules regarding eligibility to participate are. It should include a statement or description of any circumstances that would cause the loss or denial of benefits. So that would include things like, what happens if employee fails to pay premiums or terminates employment. It should include a description of any plan provisions on amendment, termination, or subrogation. It should include information regarding plan contributions and funding. So again, is it funded by employer contributions, employee contributions, or as typically occurs, is it funded by both types of those contributions? It needs to include information on how participants can submit a claim for benefits and appeal any denied claims. It must include the statement of ERISA rights, and that is a DOL model statement that tells participants that if they feel like they are not receiving benefits the way they should be, or if they think their employer is violating ERISA in any way, that they can contact the DOL, and it also gives them that DOL contact information. For group health plans, there are going to be more content requirements as well, so information on other employee benefit laws like COBRA and HIPAA, and also more description on those group health plan benefits and how they're paid. So any cost sharing provisions, pre-authorization requirements, things like that. Finally, there's no requirement to provide SPDs or to provide translated SPDs. So if an employer has a workforce that is literate only in the same non-English language, the employer is not required to provide translated SPDs under ERISA, but it is required to include a statement in the SPD that would offer language assistance. And of course, some employers who have a large workforce with English as a second language may decide to provide translated SPDs just as a best practice or an employee relations matter, but again, that's not a requirement under ERISA. Now, for insured plans, there are some different considerations to take into account when preparing the SPD, because most of the detailed benefit information will actually be included in the insurance certificate or booklet that's prepared by the health insurance issuer. So for those plans, what most employers do is they use a WRAP SPD. It's a very similar concept to the plan document WRAP. The insurer certificate will include a lot of detail about the benefits under the plan, the claims procedures, the subrogation rules, all of that, but it won't include all of the ERISA required information. So it won't include, for example, the ERISA statement of rights. It might not include all of the plan identifying information. So a WRAP document can be used in conjunction with that insurer document to provide a complete picture of the plan. And sometimes when you talk about health plans, it's very common for that plan document and SPD to be combined into one document. That's not typically done for retirement plans because retirement plans are so much more complex. But for health and welfare plans, it's very typical for the plan document and the SPD to be combined. So one WRAP plan will serve as both the plan document and the SPD. When there is a material change to the information that's included in the SPD, ERISA does require that change to be communicated to participants. Instead of going through the hassle of issuing a new SPD booklet, which again can be 30, 60 pages or even more, a plan administrator could use a summary of material modifications or an SMM to communicate that change. And typically an SMM is only going to be a couple pages long, and it's just going to describe that change in benefits or change in plan rules. There are some pretty generous deadlines for providing the SMM. The general deadline is 210 days after the end of the plan year in which the change was adopted. So that's a pretty long deadline, and most employers, just as a best practices measure, will issue the SMM before then. Typically, employers will include that with their open enrollment materials. So employees know what changes are going to be happening to their health plan that next year. If the change is a material reduction in group health plan benefits or services, then the deadline is 60 days after the change is adopted. Also, the next slide that I'm going to be talking about goes over the summary of benefits and coverage, or SBC requirements. Keep in mind that under this requirement, plan administrators must give 60 days advance notice of material modification in plan terms that take effect during a plan year and affect the content of the SBC. And I will mention that when the DOL audits, they will ask for the SPD, but they will also ask for any SMMs that were issued. And the SMMs really become part of that SPD, so they will ask for all of those. So what is the SBC? It's a short summary of the plan's benefits and coverage required under the ACA. It's intended to be a concise, to-the-point document that provides simple and straightforward information about a health plan's coverage. This requirement went into effect for most plans a few years ago, so we're all probably familiar with the SBC. The SBC is another document that the DOL will request in the event of an audit. And it must be provided by the plan administrator and insurer, but there is a very important non-duplication rule that provides that if the insurer or the plan administrator provides it, then the other entity does not. So for insured plans, typically the carrier is going to be putting together the SBC for the plan. As I mentioned before, there is this 60 days advance notice rule to keep in mind. If there are changes during a plan year that would affect the design of the plan and that would be reflected on the SBC. In addition to the SPD and the SBC, which have to be provided to participants automatically, a plan administrator must provide certain documents upon written request by a participant. So, for example, upon written request, a plan administrator must provide the latest SPD, including SMMs for the plan. The copies generally have to be provided within 30 days, and they also have to be available at the employer's main office in case employees just want to look them over. Requests for health plan documents by participants are fairly uncommon, but it is important for employers to be familiar with these rules. This is because the potential consequences for not complying with a written request for plan information can be pretty severe. Disgruntled participants can complain to the DOL when they don't receive the documents that they've requested, and this could potentially trigger a DOL audit. Also, participants could sue under ERISA's enforcement provisions, and a court could find the plan administrator liable for a penalty of $110 per day for each day from the failure to provide the requested documents. So another document that could potentially trigger an audit is the Form 5500. Many, but not all, ERISA plans must report plan information to the DOL each year using the Form 5500. Small welfare plans, however, are completely exempt from the Form 5500 filing requirement if they meet certain requirements. First of all, the plan must have fewer than 100 covered participants at the beginning of the plan year. For this purpose, participants are employees and former employees, so COBRA participants, who are covered by the plan. Covered dependents are not counted for this purpose. Also, the plan must be unfunded, which means that benefits are paid from the employer's general assets, or the plan must be insured, which means benefits are paid through an insurance policy. The plan can have a combination of insured and unfunded benefits and still qualify for this exemption. Having participants contribute to the cost of the plan will not typically jeopardize a plan's unfunded status. All right, the next compliance topic that we're going to be talking about is fiduciary responsibility. In addition to the reporting and disclosure requirements, DOL auditors can investigate whether there have been any violations of ERISA's fiduciary obligations. So it's important for employers to understand, first of all, who is an ERISA fiduciary. The test for determining who is a fiduciary is a functional one. Anyone who performs a fiduciary function is an ERISA fiduciary. So fiduciary functions include exercising discretionary authority or control regarding the management of an ERISA plan, exercising any authority or control over the management or disposition of plan assets, rendering investment advice for a fee. That typically comes into play for retirement plans. Having discretionary authority or responsibility in the administration of the plan. Those are all fiduciary roles. Keep in mind that fiduciaries are the major important actors with respect to an ERISA plan. Individuals who perform administrative tasks based on a set of guidelines are usually not ERISA fiduciaries. So, for example, an employee who's sending out open enrollment packets to employees will generally not be an ERISA fiduciary just because of that. ERISA describes 5 basic duties of an ERISA fiduciary. ERISA requires that fiduciaries act with undivided loyalty, which means they must act solely in the interests of plan participants and their beneficiaries for the exclusive purpose of providing plan benefits or paying reasonable expenses of plan administration. They must act with the care, skill, prudence, and diligence that a prudent person under similar circumstances would use. They need to diversify the plan's investments to minimize the risk of large losses. And again, that's more of a retirement plan issue. And they also have to act in accordance with the plan's documents. So again, going back to that theme of why it's important to actually have plan documents. When looking at fiduciary roles and duties, there is an important distinction between fiduciary functions and settler functions that are performed by the company that's sponsoring the ERISA plan. ERISA's fiduciary rules do not apply to settler functions, and settler functions include business decisions such as deciding to amend or terminate a plan. For example, an employer would not be subject to ERISA's fiduciary duty requirements when deciding whether to sponsor one type of plan over another. So deciding whether to sponsor a high deductible health plan over a more traditional health plan with a lower deductible. That would be a settler function that does not implicate ERISA's fiduciary duty requirements. Also, fiduciaries can sometimes delegate those fiduciary duties to third parties. That is permissible under ERISA, but it doesn't get the plan sponsor completely off the hook. The plan sponsor would still be required to prudently select the third party that would also serve as a fiduciary, and also to monitor that third party's performance. A person who is an ERISA fiduciary can be liable for a breach of fiduciary duty. The liability could include personal liability for damages or profits. The DOL can impose a 20% penalty. The fiduciary could be removed from his or her position. And also in this area, criminal penalties are possible, and the DOL does pursue criminal action for fiduciaries who violate the ERISA requirements for plan fiduciaries. There is a correction program that is available to correct any errors that a fiduciary would identify, and that's a pretty popular program. They receive about 1,500 applications per year, so it's something to keep in mind if an employer is doing a compliance review and does identify some fiduciary problems. So now that I've covered some of these basic ERISA compliance issues, we're going to switch gears and talk about the Affordable Care Act and some of the other federal laws that impact health plans. And this is a topic Erica is going to cover. So just hold on a moment and we will switch the controls over.
All right, thank you, Erin. And as Erin mentioned, we're going to talk about some additional items related to health plan compliance. Since we're in the compliance review portion of today's webinar, letting you know just some of the things that the DOL will be looking for, providing some additional explanation around those so that can help you dig into areas that you might want to look at in your own situation. So, of course, the Affordable Care Act has added a number of complications for employers when it comes to offering health plans or deciding whether to offer health plans in some cases. So we want to go over some of the things that the Department of Labor is looking at when they are conducting their audits. So now that a number of these health plan requirements and mandates have taken effect, the Department of Labor is starting to incorporate them into their audits, and they are using that audit authority that they have to make sure that employers are in compliance. So first of all, grandfathered plan status is an item that the Department of Labor will review as we move further and further away from the date the Affordable Care Act was enacted fewer and fewer plans are retaining that grandfathered status. However, if you have a grandfathered plan that provides some benefits to you because there are certain parts of the ACA that will not apply to your plan. In that case, what you need to do is make sure that you keep records that support your grandfathered status. So if you are saying, we have a grandfathered plan, we don't have to comply with some of these ACA requirements, the Department of Labor will basically want proof of that. And they will say, well, show us your plan design and your plan terms from March 23rd, 2010, a date burned into my brain forever, compared to what it looks like now. And we will make a comparison as to whether your plan has changed too much to still keep that grandfathered status. Because grandfathered plans do not follow all of the ACA mandates, there is also a requirement for those employers to provide a notice to participants, just letting them know that. And the notice says something like, this is a grandfathered plan. Accordingly, it does not have to incorporate all of the ACA required benefit mandates or, plan design rules. So it just informs those participants that some of the things they might hear about will not necessarily apply to their benefits. So some of the things that non-grandfathered plans will have to incorporate that the Department of Labor is looking at is whether they cover preventive care services as required and without cost sharing, and that includes things like the Women's Preventive Care Services, including the contraceptive coverage mandate. Now, there are some exemptions for certain plans for that particular piece of the mandate, but in general, non-grandfathered plans should by now be covering those preventive care services. There are certain participant notices that have to be provided. So, for example, we have patient protections that are available. Those relate to the ability to choose a primary care provider, as well as being able to use certain emergency services. Non-grandfathered plans also have more comprehensive claims and appeals procedures and requirements that they have to follow. So the Department of Labor, when they are reviewing these plans, will be taking a look to make sure that those requirements are being met. Now, all plans have to incorporate certain changes that were made by the ACA. So, for example, the requirement to cover children of your employees up to age 26. The Department of Labor will look at your plan terms and your eligibility terms, make sure that you are covering those individuals as required. Because the DOL usually is looking back at what you have done in the past, as well as things that are going on right now, they might look for how you handle that transition to the age 26 coverage. There were some additional enrollment opportunities for children who had previously aged out of the plan, so they might want to know, how did you handle that when it happened? Rescissions of coverage or retroactive cancellations are generally prohibited now under the Affordable Care Act. There are some exemptions for fraud or material misrepresentation, but the ability to rescind coverage has been very limited. So if coverage has been rescinded, the Department of Labor will want information on that to make sure it complies with the rules. Lifetime and annual limits on essential health benefits have essentially been eliminated, so the DOL might look for any specific information about whether your plan imposes those or when it made a change. And then, as Erin talked about, the SBC is something that will apply to plans, and the DOL will be looking for that. Now, the DOL normally will start looking at compliance with some of these items after that requirement has taken effect. Obviously, before the rules come into place, no one is expected to be following them if they're not affected. But there's usually a little bit of time once the rules are effective before the DOL starts looking at them, because there will be time, they'll be expecting employers to be implementing these rules, and then once they're effective, they'll start incorporating additional items into their compliance review. So some things have taken effect somewhat recently. I know in some cases there are plans that are able to stretch out those compliance deadlines if they're insured plans, depending on the transition policies in their state. So DOL audit requests are expanding. They will continue to expand as additional requirements of the law take effect. But some of those items would be the prohibition on excessive waiting periods, which took effect last year for most plans. So anything over 90 days is generally prohibited. Coverage requirements for individuals who are participating in clinical trials will have changed and will be part of those reviews. Getting rid of your pre-existing condition exclusions is something that the DOL will be looking at, whether that has happened. In some cases, they might still be looking at, what did you do over the last few years when those were still available? That has been a big part of document requests in the past. And then also cost-sharing limits on essential health benefits are something that are kind of ongoing right now. And so there are some changes that are being made to those rules as well, and that relates to the out-of-pocket maximum for plans that they'll have to incorporate. So let's look as well at some specific group health plan requirements. So COBRA is another federal law. You're probably familiar with it. And COBRA is, I guess the name of the statute isn't important. No one cares about that. Consolidated Omnibus Budget Reconciliation Act, that doesn't mean anything to us normally. COBRA means continuation coverage. So group health plans that are subject to COBRA, and there are some a small employer exemption there, but most group health plans under COBRA have to provide continuation of their group health coverage if there has been a change in eligibility due to a qualifying event. And those are generally going to be the termination of employment or reduction in hours, the death of the covered employee, the divorce or legal separation from the employee, or losing dependent status under the plan. So in those cases, if we're subject to COBRA, we will have to provide the opportunity for participants to continue their coverage for a period of time. Part of COBRA relates to providing notices. So plan administrators are required to provide certain notices to plan participants and qualified beneficiaries. So an election or an initial notice, just letting them know, hey, if you lose coverage under the plan because of these events, there will be continuation coverage available. An election notice for when someone does experience a qualifying event, they will be instructed on how to elect COBRA. And then there are some other notices as well. So for example, if someone reports a qualifying event and said, hey, this happened to me, so I should get COBRA, if it's not actually an event or if for some reason COBRA is not available, we have to provide a notice of that, as well as a notice of early termination of COBRA coverage if that happens. There are some instances where we can terminate that coverage early. Employers are able to charge participants or qualified beneficiaries for the cost of the coverage, actually up to 102%, that additional 2% taking into account the administrative costs and burden. So that is something that the Department of Labor will be looking at. If they are auditing your plan, they will be interested in what are those documents and what are your policies regarding COBRA. Have you been complying with all of the rules? So I mentioned there was an exemption from COBRA, though, so we have some more information about that here. Generally, if you are in the private sector and you have a group health plan, if you have at least 20 employees on average in the last calendar year, you will be subject to COBRA. And also state and local governments are going to be subject to COBRA, even though they're not subject to most of what we talked about today. So there are certain health plans that are exempt, so federal government plans and also those church plans that we talked about, because overall they're exempt, do not have to offer COBRA, although there potentially would be state continuation coverage requirements that might apply for any of these situations, but that would not be something within the review of the DOL. So next we have some additional group health plan requirements that I want to mention that may come up in a DOL audit. HIPAA is one federal law that may be reviewed by the DOL, so they're responsible for enforcement of this law. And that stands for the Health Insurance Portability and Accountability Act. So that tells us a little bit more about what's going on with that federal law. But generally, HIPAA covers health coverage portability, so the ability to get into a plan at a new employer. Health information, privacy, and security, so HIPAA privacy and security rules, as well as administrative simplification, and that's kind of a misnomer, I guess, for some of the things that plans and providers will do to communicate when they're talking about paying for benefits. But really what I want to touch on today is the portability rules, because the DOL will generally incorporate a review of these rules as part of a DOL audit of a health plan. Now, previously, certificates of prior creditable coverage were required under these portability rules, and that is how people could get into a plan of a new employer more easily, rather than having a pre-existing condition exclusion apply. Now, because those rules have changed, those certificates of creditable coverage at the end of 2014 are no longer, or were no longer required, so they're not required this year. Now, that doesn't mean the DOL won't ask for what you did in the past. So it can depend, how far back are they going to look. Usually not too terribly long from the date of the audit letter, but because this has been a recent change, they may be looking for what you've been doing in the last few years. The HIPAA rules also provide special enrollment rights when a life event occurs. So, for example, if you get married or you have a baby, these are the rules that allow you to enroll your new family member in the plan. So the DOL is generally very interested in whether you are following those rules. There are also discrimination rules built into HIPAA, and those prohibit discrimination in eligibility, benefits, and premiums based on health factors. So the DOL might want to take a look at, how are you treating people? Are you treating them differently because they are sick or have high claims? So that's something definitely to be mindful of, that HIPAA has these requirements related to discrimination. And then as well, the HIPAA rules about guaranteed availability and guaranteed renewability were expanded by the Affordable Care Act. This may not be something that the DOL comes to the employer asking about. This may be more of an insurance carrier issue, but just something to note that is included in the HIPAA rules. So this slide shows us some additional group health plan requirements that the Department of Labor will normally ask about, and some of these things may be included in the SPD otherwise, or in the plan document. Otherwise, they might be required to be addressed separately. So the NMHPA, or Newborns and Mothers Health Protection Act, is one requirement for health plans. And this is the federal law that was passed to require minimum hospital stays after childbirth. You may remember, I guess this is a number of years now, where insurance carriers were really restricting benefits, and there was kind of an uproar that women were being turned out of the hospital very quickly after giving birth. And this federal law protects them from that really fast turnaround with the discharge from the hospital. There is a specific notice that has to be included in the SPD about these minimum hospital stays that are available. Mental health parity rules also apply to group health plans, and they will require that plans cover mental health and substance abuse benefits in order to make sure that they are on par with medical surgical benefits. So there are requirements that if you offer certain types of coverage, they have to meet parity rules. The Women's Health and Cancer Rights Act is a federal law that requires benefits for reconstructive surgery after a mastectomy. And there is a notice that goes along with that, letting participants know about their rights. And that has to be provided at certain times, both at enrollment and each year. So that might be done, once someone enrolls in the plan, but then if there's an annual enrollment, we may be providing it at that time. CHIPRA is the Children's Health Insurance Reauthorization Act, and this builds on top of the HIPAA special enrollment rules that we mentioned just a minute ago. So there are some special enrollment rights for employees and their dependents that relate to eligibility for subsidies for coverage under these CHIPRA programs, or CHIP programs. There is an annual notice requirement if you are in a state where premium assistance subsidies are available. And the DOL does have a model notice for that, and they reissue it. I think it's twice a year that they do fairly regularly, just updating the states that are offering those premium assistance subsidies. So it's an easy way to determine whether your state has those available. Now, to finish up, I'll turn things back over to Erin to talk about record keeping, and then I know we have at least a question or two, and we can get to those before we end for today.
Okay, so remember back to that audit request letter and how much information it requested. Keeping complete and accurate records will help move along the audit process. It will allow an employer to respond to the DOL in a timely and organized manner, and it will also help give the DOL an accurate description of the employee benefits that you offer and how they've been administered. So when creating a record-keeping system, it's essential for employers to keep track of the notices that they are required to provide to participants. They should keep a copy of the notice that they've provided, as well as some sort of distribution log that shows when the notices were provided. As a general rule, records should be kept for 7 years. Many times these records are going to be held by another entity. So if you have an insured plan, perhaps some of the records are being held by the insurance carrier, or if you're working with a TPA or another service provider, that TPA or service provider may have those records as well. In these situations, it's just important to touch base with the carrier or with the other service provider to make sure that they are retaining the records and that they would be available to you in the event of a DOL audit. So here's an example of a type of record-keeping system for one requirement that Erica mentioned a moment ago, and that is the ACA requirement to provide a notice of patient protections whenever the SPD or similar description of benefits is provided to participants. So under the record-keeping system, you could keep a copy of the actual notice that's provided to participants, and that might be included also in your SPD. And you would want to just document when is it being provided, who are you providing it to, and then keeping a list of the participants, again, who you have provided it to. And this would help too with documents like the SPD or any of those notices that you are required to give participants. A record-keeping system to show that yes, in fact, you do have this notice and that you are providing it according to ERISA's deadlines for delivery, and also you might want to document how you've provided it, especially when it's the SPD and there are strict requirements for how you need to provide it. You could document that you sent it via first-class mail or electronic delivery, and here's how you met the requirements for electronic delivery under the DOL guidelines. So again, we've been talking about what a DOL audit might look like and how to best prepare for this type of audit. The best time to prepare is right now, before you're contacted by the DOL. Going through a compliance review, getting your paperwork in order may take some time now, but it would definitely pay off in the future in the event you're selected for audit. Being ready in advance can help the audit process run more smoothly. It can also help minimize the time and expense involved in responding to the DOL's request. We've reached the last part of our presentation today, and this is the part where we're going to respond to any questions that we've received during the webinar. So I think we do have 1 or 2 questions that came in. Thank you for those. If you have a question that you haven't submitted yet, you can go ahead and do that by using the Q&A feature on the right-hand side of your screen. And if that's not showing up, you can look at the top of your screen, look at the look for a button with a question mark on it that says Q&A. And you can go ahead and open that up and submit your question. Just make sure that you would select Send to all panelists so that Erica, Patrick, and I can all see it. So just give us a moment. We'll go through what we've received, and we'll start answering questions.
All right, thank you, Erin. So actually it looks like we have one question in the queue right now, and someone had asked if we do want to obtain legal counsel to guide our company through an audit process or SPD guidance, what credentials should this counsel have? So this is really going to depend quite a bit, I guess, on what maybe your specific location and what kinds of resources are available there. We would definitely recommend, having kind of lived in this world in the past, having an attorney, if you feel the need to have one involved in the DOL audit with you, who has experience specifically with employee benefit plans. And that can be kind of a narrow practice area. It might be unusual for a very small firm or a solo practitioner to have a lot of experience in employee benefits work. Maybe something that is more common in a medium to larger sized firm, many of which might have an employment law practice that incorporates employee benefits, or in some cases, such as the firm Erin and I worked at together, it had its own specific employee benefits practice group. So that could be one option, where you might work with a firm that has a number of attorneys who are specifically dedicated to employee benefits compliance. Regardless of the type of firm or the type of law office that you might be talking with, if you find one that has employee benefits as part of their practice areas, you would potentially be interested in talking with someone who has previously been involved in working on a DOL audit or multiple DOL audits, or at least doing ERISA compliance. So that's something to look for, ERISA compliance experience. Now that we are well underway with the Affordable Care Act effective date, someone who has experience in that area as well, then that could be something that would be valuable. And lots of employee benefits practitioners, just kind of by virtue of the fact that most plans are so impacted by the ACA, are starting to wrap that into their practice. So those are potentially some things to look for. Of course, it's going to depend on the resources that are available in your area. In some cases, though, for purposes of federal law compliance, employers in one area may use a firm or an attorney that has a more national practice, and not necessarily someone who is located in their own state. So even a larger city that is close by could be something that is available to you. So we have some 5,500 questions that have come in, and I wonder, Erin, if you would be interested in looking at those if they're showing up in your feed as well.
Sure. So the first question is there a separate 5,500 that needs to be submitted for employee benefits and employee retirement plans? So how I understand this question is, are there two separate Form 5500s that would need to be created for an employer's employee welfare benefits, so like their health plan, their dental plan, vision plan, and their retirement plan, so like their 401k plan? And the answer to that is yes. Generally, there is a 5,500 requirement for each different ERISA plan. Now, you can combine your welfare benefits all under one plan, and some employers who are subject to the Form 5500 or employers who are subject to the Form 5500 generally do want to do that or tend to do that just because it helps make the 5500 process easier. But there are some considerations to take into account before doing that. But if you have like a medical plan that's grouped with your vision and dental, there would be one Form 5500 for that. You can't group your retirement plans in with your welfare benefits. So you're always going to have a separate $5,500 for your retirement plan. And again, there is that small employer exception to keep in mind for your welfare benefits. So if you do qualify for that, then you wouldn't be required to have a Form 5500 for those benefits. Let's see, I think there was another Form 5500 question as well. So is my company exempt from the 5500 since we pay 100% of benefits for employees and have less than 50 employees? So generally, the two requirements for being exempt are that you are a small employer, so you have 50 or less than 50 participants covered under the plan, and that's going to look at the people who are actually participating in the plan. So it doesn't necessarily look at all employees. It more looks at who is actually participating in the plan. And I'm sorry, it's not 50, it's 100. I misspoke. So again, you have to have fewer than 100 covered participants under the plan at the beginning of the plan year. And like I said, that's different than the number of employees you have. So actually, if an employer who has even, a larger workforce, maybe 200 employees, if they have a separate FSA maybe where they only have 75 employees participating, that may qualify for the 5500 exemption. The other component is that the plan has to be unfunded or insured. So if you have an insured plan, then it could qualify, or if you have a self-funded plan where you pay out of your general assets, that could qualify as well. And it doesn't really matter if you have participants contribute to the cost of coverage. That won't usually jeopardize that portion of the qualification for the exemption.
All right, it looks as though we have gotten to the end of the questions that have been submitted, so thank you to everyone for submitting your questions. If questions come up after today, of course, you can always reach out to your contact at Synergy Solutions Group. And with that, Patrick, I'm going to put you on the spot a little bit and ask if you had any closing remarks, and I can open your line if so. So your line is open if you would like to close us out if you're still on the line.
All right. I appreciate you all taking the time to listen to what Eric and Erin had to say. It was very thorough. And I know a lot of information was presented to you all at this time, and there's probably an overwhelming feeling of, oh my gosh, what is all this? Well, the good news for you all from this is that many of these aspects that have been discussed are being set up for you and are being done, and you don't even realize it yet. With that being stated, there is going to be additional information that we will be reaching out to you, either myself or my colleague, Betsy Bray, will be contacting you all to discuss materials for SBDs, the summary plan descriptions, what we're doing with regards to your compliance to COBRA, or in particular cases, state continuation of, along your based upon your company size, as well as all these notifications about all the little acronyms that are at the end. So I don't want you to feel overwhelmed, and this is more to let you know what is required and what is going to be done on your behalf to give a little ounce of prevention for the pound the cure scenario along those particular lines. And concerning the 5500s, overall that is a concern that based upon the client size here, you all do not have to be concerned about. So that's all I have at this time.
All right. Thank you, Patrick. And thank you so much to everyone for attending today. We do know, as Patrick said, it's a lot of information, but at least having an overview of that can help you determine what kinds of things might impact us, what kinds of things like the 5500 are out there, but we don't have to worry about right now because of our size. So hopefully that is helpful to give you an idea of just what's going on out there. And of course, as Patrick said, what Synergy Solutions Group is helping you with. So again, thank you so much. And thank you to Synergy Solutions Group and to Patrick for having us and to talk with you today. Hope you all have a great day.